Okay, we'll call this hearing back to order, and we're still on commissioner questions. So I think Commissioner Hamilton.
Thank you, Mr. Chairman. Happy to have y'all back this afternoon.
Thank you.
Yeah. I'm sure you had hoped to be through by this afternoon. And I just have a few questions. What is the opt-out fee on the smart meters?
I do not know it offhand, but back to a question I got from Commissioner Belzer earlier, we do have Don Schneider here who will testify later today, who will have details on that.
Okay, thank you very much. And this next question, either one of you might want to chime in, but do you expect the demand-side management and energy efficiency programs to suffer any on the increasing costs and fixed costs?
No, we're going to continue to push that. Absolutely. We've been very effective in terms of how many kilowatt hours we've saved with our demand-side management and energy efficiency programs. I believe, the savings are really tangible, sizable, and the hundreds of millions of dollars, in fact, since these programs were initiated. So we'll continue to push those. But clearly, if the variable charge is lower than the used to be before, the savings may not be as great as they were before, but clearly there's still value in pushing those, so they will not suffer.
Okay. And I know many people had some questions about the solar and the cost. What is the method now that you have for residential solar, the amount they receive back for excess power?
They receive full retail credit for excess power. So back to one of the public hearings, there was a customer who claimed he was receiving only 4 or 6 cents. That's one of the questions I followed up on, and that's not correct. They do receive full retail credit for excess power that they put back on the grid.
I had thought that was correct, but thank you. I appreciate both of you being here. Thank you very much. That's all I have, Mr. Chairman.
Thank you, Commissioner. Commissioner Whitfield.
Thank you, Mr. Chairman. That went a little quicker than I thought. Got a few questions for both of you. Some of it you may end up punting some of it to Witness Miller, and I understand that, but I think I'm going to stay at a fairly high level enough to where we won't get too far into the weeds, at least with your panel, on these questions. First of all, Mr. Garty-Tego, Commissioner Belzer asked you a question about the kind of asked one of the things I was going to ask. I just want to do a follow-up with her about the credit card, debit card program. And, of course, you talk about it in your testimony on page 23. What information, my follow-up is, what information did you use to conclude that the credit card payments would double in growth by 20% or up to 20%?
It's an estimate, and our witness, Quick, will be able to provide additional details on that. But I will say today, when customers pay by credit card, and it's a fairly low percentage today, and based on customer feedback, we know part of the fact that it's a low percentage, and it's also a major irritant for customers, is the fee that is charged by a third party. Mm-hmm. It's not charged by Duke. We use a third-party vendor to process those payments, and the third party charges the fee. And it's a major issue of irritation and dissatisfaction for our customers.
Right.
And that's why we're proposing it. But Witness Quick will be better prepared to tell you how we came up with the estimate.
Well, just a quick follow-up along those lines, and if you need to punt it to Witness Quick, okay. By your projections or by the company's projections, how much will this fee impact each residential customer's bill?
I'd like to defer that to Witness Quick.
Witness Quick, okay. I'll make a note of that. Next, I kind of for both of you, I'm going to kind of be at a little bit of a high level. Start off with you, Mr. Garty-Tego, and Ms. Smith. If you need to jump in, that's fine, and there will be some for you down the road too. But so we won't leave you out. Mr. Garty-Tego, of course, a large part of your request here is for the combined cycle plant in Commissioner Irvin's district up near the community of Pelzer. And of course, you've now had almost a year for it to be. I think next month, April, it'll be a year since it came into service. Is that correct?
That's correct.
And of course, 750. Well, actually, a little more than 750. 753 megawatts is quite a large facility. Of course, toward the level of some of the nuclear baseload plants in terms of megawatts. But a couple of questions along those lines. Now that you've had a year, how is that working in the fleet in the Duke system, and what benefits are you seeing? Is the company seeing? What benefits are ratepayers seeing? What business benefits are there overall to reliability and so forth?
It is working very well. I will say witness Imel is here, who can also address the performance of our generating fleet. As I said in my opening statement, it is a gas-fueled facility, so certainly the emissions from it are significantly less than the coal plants that were at that same site before this was built. With the low gas prices we have today, it gives an opportunity for the company to run at lower cost than we otherwise would be, and all those benefits flow directly to customers. Certainly, having adequate generation is an important factor in maintaining reliability of the system as well.
I want to talk about the Lee site in Cherokee County for just a minute, and just briefly tie back to that facility, to the combined cycle facility. And I'm not going to rehash. You all had a great exchange with Mr. Elliott on the breakdown of the revenues and AFUDC for the Lee facility in Cherokee County. So I'm not going to rehash that. But back to his point about the percentage that South Carolina ratepayers would have had to pay for that. So let's just be clear on this combined cycle gas plant. It's my understanding Duke does not get all 753 megawatts. You only get 650, I believe. The other is owned by North Carolina Electric Co-ops. Is that correct?
North Carolina Electric Membership Corporation, yes.
And let's go a little further and be clear. Unlike the Lee nuclear site, all of the 650 that you receive does go to South Carolina ratepayers only. Is that with the exception of the part that North Carolina EMC gets?
That's not correct.
That's not correct.
All our generation, our system generation, which means that some of it goes to serve wholesale customers, some of it goes to serve North Carolina customers, and some go to serve South Carolina customers. So there's definitely a cost allocation that occurs to cover the cost of that Lee CC plant.
Well, I was going to pull out the wholesale customers, but there is a portion that do you have a breakdown? Do you happen to know the breakdown, or is that for another witness of what portion North Carolina customers?
I think witness Smith can answer the allocation.
Or Miller?
Yeah, I can.
Oh, you okay? Oh, Ms. Smith. Okay.
Yeah. So normally on our allocation, if we're just allocating North and South Carolina at 70-30, but our wholesale customers make up about 9% of Duke Energy Carolina's system. So probably 65-29, I think. So 65 North Carolina, 20% South Carolina, and if you do the wholesale customers, 9%.
And you're specifically talking about the combined cycle gas plant only, the breakdown you just gave me.
Well, all of our generating plants.
Okay.
Go into that, have that allocated. They're all allocated. The cost are recovered from all of our 3 jurisdictions.
Okay. Mm-hmm. So you've had almost a year with that facility. Back to the Lee facility, the Lee nuclear facility. And again, I'm not going to rehash what Mr. Elliott did, but I do want to ask a question. related to the cost in pursuing the NRC license, and also the other costs that we've approved in the order from 2011. That facility, you didn't get your NRC license till about a year and a half, almost 2 years, not quite 2 years ago.
Yes, that seems about right, yes.
And I just wanted to ask, maybe if I could, of course, you're stating you still have that, and you still have the option of, the option is still on the table, is what you're saying by not turning that in. But I guess what I'm asking for, why did you pursue a federal NRC license without going first down the state process like has been done in the past here? Or does the company have a reason why they, and it looked like to me it went fairly fast because we weren't part of that. But I noticed a notice, and then within just a few months you had an NRC license. There were some public hearings, I think, and then you had the license pretty quickly, whereas I've read other applications have taken 2.5 or more years.
Well, I think it took a while. It was a long process, and Witness Fallon is here and can address that process with you. It was not a quick process at the NRC. It does take a while. I think there was always an intent to come back to get a siting license or certificate from South Carolina as well. But the NRC license, certainly if you don't get that, then you don't do anything. And the license doesn't expire. So I think Witness Fallon can give you more detail, but it was not an either or. It's a both. I
just wondered if there was some type of corporate strategy as to why you went the federal route first, so to speak.
No, not that I'm aware of.
Okay. I want to move a little bit to the another large cost that you have here is for the Catawba Watery relicensing of all the hydroelectric dams in that Catawba Watery system with FERC. And I know that was a lengthy process, and you've got about $126 million. Maybe you have it, maybe I missed it, but what portion of that, or do you have it broken out of what portion of that was legal, the legal portion of that?
I do not know that.
Do you know that, Ms. Smith? Maybe there's another witness that may have that.
Yes, or we can get it for you.
And I know that there are certain conditions that came with the FERC 40-year license that you received, and you are doing a lot of improvements, enhancements, that sort of thing. I know some of those have not been done yet, but some of them are ongoing. Do you have a little bit of information on that, or is that for another witness?
I think that'll be for another witness.
Okay. We'll punt that one down to a later witness. Lastly, Mr. Gartitego, during the night hearing, we had some, I think you've been questioned a little bit about this, maybe from Mr. Nelson already, but I want to go just one step further. There seemed to be, in a lot of cases, I know you cited how many testified, almost a complete disconnect between your CSRs, your telephone market, your telephone people in the office, your CFRs who are in the office, and your linemen and your field personnel and your engineers as to what's actually going on in the field. And so much so that customers were sounding like they were having a hard time getting your people, your CSRs, to understand what their problem was. Do you think that your CSRs maybe need some physical training where they actually see physically what the problem is, so that maybe they can better relate to the to the customers when they call in and try to explain specifically what their problem was? Because I heard that in Anderson, Spartanburg, and Greenville. I heard that all three places.
Well, our customer service representatives are trained. They go through regular training. They have periodic training to update them on the business and the types of calls they're likely to get. Certainly, if they had more exposure to what happens in the field, they would better understand it. But I do think, or again, to put it in context, I do think that if you think about the number of calls we get a day, the number of requests we get for folks to come out and do something, that may not, what we heard in these night hearings may not necessarily be representative of what happens every day. I think by and large, most of those calls we do handle correctly. To the extent that there's additional training required, that is a lesson learned from the night hearings that I will take back to our operations team.
Well, I was just wondering if you just had those discussions, or maybe you haven't had much time to discuss anything since the night hearings, but there are just so many that kind of stick in my mind. One, the man that that talked about the trucks being rolled, the heavy transport trucks being rolled, and all this equipment coming out, and then nothing happened. And there were a couple of, that's one that sticks in my mind, but there were several instances where it just seemed pretty clear that your person inside the office on the other end of that phone did not understand. And they also had long wait times and hard to get through to. Seemed to have problems getting through. A lot of them expressed, the lack of having a local office and being able to come in and see someone face to face. I know it hadn't been long since those hearings, but have you had any thoughts or discussions along those lines of how you might improve that?
Yes, so the gentleman whose case you're referring to, that's one where I believe the letter he showed you was one that was directed to me. I think it did come to our office, and at that time, there was no action required at that time because the time had passed, his lights had been fixed. But that's one of the kind of topics that I would take to our team, our operations team meeting, and ask what we could have done differently, and to encourage our team to be more responsive. So we do get some of those calls, certainly, and we try to address them as they come up. I will say since the night hearings, I have not had the opportunity to investigate every complaint that came up during the hearings.
And I certainly realize that was just last week. Lastly, and I guess I'm going to stay with you on this one as well. Other complaints, and Mr. Nelson kind of went this way, or maybe one of our commissioners did, talking about the smart meters. We heard, of course, a lot of complaints about that. And I think you stated in response to a question on the stand this morning that the resident you looked at who acknowledged his bill had gone from $400 to $900, you said you checked and there was no $900 bill. But did you, in fact, without calling that person's name, did you indeed check and see that his bill may have gone up some from $400? In other words, if it wasn't $900, was it $500 or $600?
Yes. And as I explained in my answer too, there was an electrical issue that caused his auxiliary heat and the heat pump to come on, which is a sort of an emergency heating system. So that would definitely cause the bill to be higher than it otherwise would be.
I don't guess you've had time to investigate some of the other witnesses, public witnesses, who complained about getting the smart meter in their bill going. I know it's been a short time, but
not yet.
We did seem to hear a lot of that.
Yes, and I don't have the transcript to all the hearings yet. Some of them did talk to our folks, some did not. That particular gentleman's case just seemed sort of extreme, so that caused me to follow up very quickly, and that was the outcome of my investigation.
Well, thank you. That's all I have, Mr. Chairman.
Thank you, Commissioner Whitfield. Commissioner Urban.
Good afternoon.
Good afternoon.
In reviewing the pre-filed testimony, Mr. Herbert Robert Hebert, am I pronouncing that correctly?
Perfect.
Perfect. Indicated that the return on equity should be in the range of 10.25 to 11%. I think you said 10.5 earlier. If subject to check, if he said 10.25, would you agree that that's probably the low end of your perspective?
Yes.
And I believe North Carolina, did you agree on a return on equity of 9.9, or did the commission order that?
We agreed with public staff on 9.9.
Well, if that was good enough for North Carolina ratepayers, why would that not be appropriate for South Carolina ratepayers?
Well, I think after that case, interest rates went up a little bit more. I do think that, particularly with some of the proposals in the ORS's testimony, our risk is higher here, among other things. And ROE is supposed to be reflective of the risks of the jurisdiction, yes.
Well, interest rates have just come down this week, though, haven't they?
Well, those would be short-term rates.
Yes, sir.
Right? And we tend to finance with long-term.
Right. Over how many years, approximately?
I will defer to Jack Sullivan on that.
Right. But long-term rates have recently come down as well.
Well, I'll defer to Jack Sullivan on that. But I would say, I mean, there's a need for regulatory stability, and all that tend to impact risk. But I think Mr. Hebert and Jack Sullivan will be able to tell you more about how we arrived at our recommendation.
But a 9.9 return on equity is not an unreasonably low figure, is it?
Well, I wouldn't say it's an unreasonably low number. No.
This is what Dominion agreed to in our case recently.
Yes, I'm aware of that.
And so they thought it was reasonable. I just wonder why you don't.
Well, again, I think in a settlement context, there are other issues that are being addressed. And in the totality of the circumstances, I might be willing to take a 9.9, right, when other factors are present.
Well, could it be that Duke Energy's CEO gets a $7 million bonus in the event that the rate of return exceeds 10%? Could that be one of the factors that you're taking in consideration?
No, sir.
Isn't it true that she got a $7 billion incentive or bonus to if she got
you say $7 billion?
$7 million?
I'm sorry.
Bonus.
In 2017, she got a $7 million return
That's right.
bonus. Yes.
And that was to get 10% ROE.
No.
No?
I don't believe so.
Don't think it was tied to that?
No. It was a retention bonus.
Well, the Charlotte Observer said that. I just wondered if we could verify it. Could you check that for us?
Check the Charlotte Observer?
Yeah, just the story indicated the business section had an article that said that was tied to her return on equity for the shareholders if she exceeded the 10% return on equity.
Okay, we can check that. But
All right.
I think like other employees, she's got a base pay and incentive pay.
Right.
And the incentive pay has certain measures that have to be met. Certainly earnings per share is included in some of the metrics.
Sure.
So,
It's also true that she's the highest paid CEO in the nation for electric-owned utilities, right?
I don't think so. I mean, 2017, because of that retention bonus, she may have been. But before that, I believe in 2016, her compensation was about 13 point something million.
She got a 55% increase from year to year, I believe. For
that 1 year. It's
Yes, sir.
not a recurring
Right.
bonus, no.
And I also was interested to see that Duke Energy is building a 40-story skyscraper in Charlotte to house, along with other things, to house part of your operation. I'm just curious. It's a multiple-use facility that's been announced, and you've asked for permitting from the city to build it. It's going to have over 1 million square feet, and portions of that facility are going to be rent it out to other tenants, it'll be available as a multi-use facility. Where do those profits go?
For renting space?
Yes, sir.
I don't know that. But certainly, we would not charge cost to customers, rent it out to third parties, and those profits not come back to customers.
I guess my question is, are the customers helping to pay for that, the construction of that facility?
Well, like other Duke, so just a little more context, that facility is being built to replace 3 existing facilities that we have today, some of which are over 40 years old.
One of which is being leased, I believe. Is that right?
Yes, the 400 South Tryon building.
That's right.
And it's getting increasingly expensive to maintain that space.
Yes, sir.
And we find it more prudent to move to new space than continue to upkeep 3 old facilities.
But you're going to keep the other, what you call the Duke Energy building.
The Duke Energy Center, correct.
The Duke Energy Center will remain an asset.
Correct.
And, but you are going to rent out to other third parties. You're going to lease that space out.
Yeah, I know about commercial space.
Yes, sir. I'm just in, and you haven't disclosed the cost of that project yet. I know that you bought the underlying property for about $27 million and change.
Sounds about right.
Does that sound about right? But you haven't told the public yet how much you're going to spend on the skyscraper.
Because work developing.
It's still work in progress.
Exactly.
But I guess just from a ratepayer's perspective, I'm wondering how that's financed. And if you could someone provide that information to us during the hearing, just so we'll know.
I'm sure Mr. Sullivan can help with that. But generally speaking, our facilities are, if part of it is used for the benefit of customers, that will get
that'll put in the rate base.
Included in the cost of service.
As long as it's a reasonable rent.
Absolutely.
Okay. But the other profits are going somewhere else, and I'm just curious to know where they're going. It's a fair question, I think.
Well, yeah. I mean, I would say right now it has not been built, so there's no profits from it.
But there has to be some kind of facilities plan.
And to the extent that we rent out space that generates profit, again, I don't know how that would be treated, but certainly that space would not be charged to customers.
All right, sir.
That much I do know.
Fair enough. Yeah. Okay. Ms. Smith, would you know any more about that project? Could you help us?
On the general allocation system, when they look at when we allocate the cost of a building, they look at the type of workers that are in the building. So if it's a non-regulated, they don't get charged to the regulated entities. So as Witness Gartitego said, if there is, if we are renting out space, then we will not charge the South Carolina customers for that space. It will only be the space that is being used to benefit the customers of South Carolina.
I understand that part, and that's the only thing that would be considered for the rate base. I'm just curious. I just thought it was quite an undertaking for a publicly owned utility to build a 40-story high skyscraper, and it just piqued my curiosity to know, how's this being done?
Yeah. Well, I think the financing structure is a sale leaseback.
Right.
Yeah.
So we're selling it and then leasing space.
Right. And I guess the profits will go to the shareholders. Is that the bottom line? Be a part of the return on investment?
I don't know. Again, I don't know if there will be profit because the point is, if it's not being used for customers, it will not be charged to customers.
Yes.
I understand. It's fair enough. I'm pleased to hear that you're interested in committing to the Roundup program, because I think that would be tremendously beneficial to our ratepayers here in South Carolina and other states that you represent, and I commend you on that decision. I think there are a lot of people that would participate.
I hope so.
Because South Carolina, as you know, has an issue with people that are living at or under the poverty level. And the rough calculation is we believe there's at least 1 million or more families that not families, but people. There's about roughly 5 million people in the state, and I think about 20% are living in poverty. And so I think you picked up on some of that at our public hearings, and I commend you for substantially reducing the set fees, because that would have a tremendous impact on low usage customers like the one that you set beside.
Yes.
In reference to earlier in your testimony. And it would also have a devastating impact on low-income, elderly, disabled, and minority customers throughout the state, throughout the rate base that are struggling to make ends meet. I think you heard some single mothers that are working 2-3 jobs to try to pay bills and keep the children fed. And we heard some heartbreaking stories, didn't we? We did. And it really, I think it was time well spent. And I want to thank the people that came out to share their stories, because I think it does put things in perspective. We want you to be successful as a company and have a reasonable rate of return, but we also want to be fair to our people. And that's why we're here, is to be fair and just. And so I don't ask these questions to try to embarrass you. I really don't. But I think we have to make an inquiry to reach a just result. So I appreciate you being with us today. Thank you.
Thank you.
Thank you, Commissioner Williams.
Thank you, Mr. Chairman. Mr. Garce-Tago, Ms. Smith, thank you for being here. Just a couple of questions for you as we round out this session. Mr. Garce-Tago, you had the opportunity to attend all 3 night hearings last week. Is that correct?
That's correct.
Okay. And is it fair to say that the attendees of that night hearing were somewhat concerned about the increase, the proposed increase? Is that a fair statement? My question to you, first question, would be based on what you heard at the night hearings. Would you consider the access to electricity a right or a privilege, or stated another way, a necessity or a luxury?
I believe it's a necessity, and that's why, frankly, we are a regulated public utility. That's one of the reasons why we are regulated, to make sure that as a monopoly, the Commission balances the customer's opportunity for just rates against the company's opportunity to earn a fair return.
Thank you for sharing that. I'm sure you remember that several attendees raised that point in question, actually made that exact statement and sort of raised that question. And that leads to the next question of how much is too much. We talked about the rate of return on equity, and I think you know this, but this hearing is live streamed. Our staff has done a great job to help us with opening the door, if you will, so ratepayers can see what we do. And we actually advertise that at the public hearings. So I would imagine that many of those who attended the public hearings are actually tuning in right now. And I would like to give you an opportunity to address them. What I'm trying to figure out is, with the initial proposal for the basic facility charge, I believe it was $28. It's my understanding you believe, Mr. Garce-Tago and Ms. Smith, that request is supported by the pre-filed testimony and the evidence, if you will.
Correct.
Yes.
Okay, so that's a true statement.
Yes.
In your opinion. Okay. So what changed between your initial proposal and the time where you decided to consent to ORS's basic facility charge, the $11.96?
Yes. So certainly in developing the case, I had talked to a few, but not many customers. The opportunity to go through the night hearings and hearing the feedback for the customers was absolutely impactful. Separately, I've had conversations with other stakeholders, including parties in this case. That's all very impactful as well. I think our goal was to send the proper price signals in terms of what it costs to make electricity available. And at the time we filed, we absolutely believed that that was the reasonable thing to do. But haven't heard the feedback. Certainly haven't heard some of the testimony filed about gradualism. We took a second look, we stepped back, and we said, perhaps that's not the right thing to do now. And that's why we accepted ORS's recommendation on the basic facilities charge.
Okay. Thank you for sharing that input with me. Is there any reason why you can't accept the 9.3 rate of return as proposed by ORS?
Yes, because I don't think that's fair. I don't think that's a just and reasonable return for our investors who provide the funds for us to maintain safe, reliable, and affordable electricity in South Carolina.
Okay. And again, we have a technical staff. We go through all the pre-file testimony. So I have an understanding of what you just said. But if you could break it down for just the average ratepayer, you don't think is fair. I mean, why is it not fair?
So in regulating utilities and the prices we charge, there is very long-standing precedent. Goes all the way back. I think the most cited case is from 1923, U.S. Supreme Court case called Bluefield Water Works. And in there, the Supreme Court said, when a company devotes its assets to providing public service to the community, as a public utility, as we are, a monopoly company like ours, the regulators are to ensure just and reasonable rates. But on the other hand, the investors who provide the funding to operate the business also deserve a fair return on their investment. The return on equity component is one component of our costs. As witness Smith said earlier, it is a cost. There are people who provide funding for us to make investments that serve customers. And those people have other places to put their money. They could put it in other utilities. They could put it in other companies. It all depends on what they get in return for that investment. So when other companies are earning a return of, say, I believe it was 10.85 that we saw for Georgia Power on the list that was shown, they'd rather probably put their money there than put it in a company that is only allowing 9.3. If we can't, so which means it would cost us more to raise those funds. If we cannot raise those funds, or we raise it at a higher price, ultimately customers suffer, right? Because either you don't have the funding to do what you need to do to provide reliable, safe service, or, it costs too much, and the commissions ultimately have to step in and raise rates to allow us to provide that kind of service that our customers expect. So it is an element of cost. I've heard the term used profit many times, but it is cost that we incur. And that, based on precedent, based on regulatory policy, all that must be paid for.
So based on that position, there's an argument to be made that if this commission were to decide on a rate of return that could be considered, that you would consider unreasonable, is there an argument to be made that it could ultimately negatively impact ratepayers?
Absolutely.
Okay.
Ms. Smith, I think.
Oh, I'm sorry. Go ahead, Ms. Smith.
I'm the neighborhood person that explains utility rates all the time. They find out you work for Duke, you work in the rate department. But I remember when I was younger and my aunt always invested in utilities. And I said, why do you do that and not invest in something that's going to make you a lot more money over time? She goes, because I know if I invest in utility, I am going to receive a reasonable return. I will never receive a huge return, but I will always get a reasonable return, and I will not ever get, no return. So that's why people invest in utilities, because they are assured of a reasonable return with the regulatory compact, whether they know they'll never make a huge profit.
The other element to this is, and this is stuff I've read in the press down here lately, that we are guaranteed a return. There is no guarantee to what you allow in this case. It is the opportunity for us with good management and things working out, because again, we've talked about using a historical test period. We're using historical numbers, costs and prices from 2017, when we all know we're setting rates for the future. The new rates will not be implemented until June 1. At least that's what we've asked for. So almost by definition, by the time you leave here, you're behind. And as we state in our application, as of the end of the test period, we are earning a return of, I believe, it's 6.48%, as opposed to the 7.89 that this commission on total return on rate base, not ROE. So that factors in the cost of debt plus the cost of equity. You know, the last case in 2013, this commission allowed an overall return of 7.89%, subject to check. It's in our application. And by the end of the test year, we were ending below that. You know, so it is not a guaranteed return. It is an authorized return that we have an opportunity to earn. And the only reason typically we'll come in for a rate case is because we're not earning that.
Thank you, Bill, for sharing that information with us all. Couple of questions regarding your energy conservation programs. I believe it was in Greenville where there was testimony at the public hearing that a ratepayer lived in a either manufactured home or mobile home, and that ratepayer requested an energy audit, but she was told that Duke Energy does not perform energy audits on either mobile homes or manufactured homes. Is that, do you know anything about the truth of that statement?
You know, that's one I have not followed up on yet, but that would be a surprise to me. I mean, the issue with manufactured housing is there is only so much you can do. And that's part of the issue we have in South Carolina. I think I read somewhere that about 20% of our homes are manufactured homes. And that's why we have higher bills. We don't have the highest rates in the country, which is another fallacy I've read in the papers recently. We don't have the highest rates in the country. There are people in Hawaii who are paying 34 cents per kilowatt hour. We're not paying that in South Carolina. But we have higher usage because our customers use electricity for heating, for cooling, for lighting, for cooking. Whereas perhaps in the Northeast, they could heat with oil or gas. And electricity is used in cooling and lighting. So they don't use as much, or they may not use as much. The problem with manufactured housing is it is not well insulated. They don't tend to be very energy efficient, right? So you could change our light bulbs, and I don't know why our folks wouldn't offer to do that, because that's what we do in the other homes. They have lights too. So we would do that. To the extent we could add insulation, we could do that. So I seriously doubt that we would have told a customer who lived in a manufactured home that we don't perform energy audits for manufactured homes.
Do you think it's worth the investment to whole home retrofit low-income housing to try to increase energy efficiency?
So it depends on the cost, right? In all our energy efficiency programs, there's a cost benefit that is reviewed. We had an ex parte briefing here only a couple of months ago, just focused on that. So there's some point where it's just not cost effective to make the investment. So there could be cases like that.
Ms. Smith, this question is for you. Why is the Lee nuclear plant site any more valuable than the same acreage without the benefit of a combined operating license if there is very small potential it will ever be used for a nuclear facility?
The Lee nuclear plant, we did develop the plans for it, and that's what the money we're asking for was the development of the plans. So we have incurred that cost, and it was prudently incurred when we incurred the cost. There was a few dockets here in South Carolina and we've been reporting how we've incurred our cost. So we are trying to recover the prudently incurred cost of our development. Does that answer your question?
Yes, it does.
May I add to that? So the site is also, again, we're holding on to the license, right? There are not too many sites. The license goes with the site. So if we give up the site or, dispose of it, you may have to go through the entire licensing process all over again. So that makes the site valuable.
Sure. I'm finished. I'm going to yield my time to Commissioner Irving. Thank you, Mr. Garcia-Teo and Ms. Smith.
Thank you.
Just to follow up on that site, it's very unlikely that you'll ever build a nuclear facility on that site. Isn't that true?
Sitting here today, yeah, the stars are not aligned for that, but circumstances do change.
So that license today is really not worth anything, the paper that's written on.
I think it's worth something, absolutely. Much like government policy changed and carbon all of a sudden was not as an important policy objective of the present government, we could have another government that puts a significant price on carbon, and gas prices could go up, and all of those are important factors in determining whether nuclear is the best generation option.
But that facility was never used and useful, correct?
To the extent you mean we didn't complete the facility?
Correct.
That is true.
You abandoned
We
it.
didn't complete the facility, yes.
Right. And since we're talking nuclear, have you investigated the possibility of keeping the nuclear plants that you're currently operating in service longer? Because they are clean energy. They do provide that base when the sun's not shining for peak use and so forth. I hope you have some plans to try to keep those licenses active and keep them in service.
We're absolutely investigating that opportunity right now.
And I hope the Congress may help you with some incentives, because we're trying to save our planet, and nuclear is a clean energy option.
Absolutely, yes.
And so I'm glad to hear that. I'm going to encourage you to pursue those options and try to shut down the coal facilities you do have in operation in North Carolina, or convert them to gas. I hope you're considering that as well.
Well, there are at least 2 of our facilities that we've connected dual fuel to, so they can be fueled by gas or coal. And to the extent that gas is cheaper, we do fuel them by gas.
Thank you, sir.
Thank you.
Thank you. Commissioner Belzer.
Thank you, Mr. Chairman. I thought I was finished, but I'm not. I'm sorry. Just a couple of questions, and one of them is in response to an answer you gave where you cited the Bluefield decision. And you're an attorney, correct?
Actually, I don't have a license anymore.
Oh. Well, you were trained as an attorney, were you not?
Yes, ma'am.
You know how to read the law.
I do.
Okay. And you talked about Bluefield and basically the progeny of cases that follows, referring to good management. Is that correct?
Yes.
I think some of the terminology is economical and efficient management, is it not?
Correct.
And so, granted, looking at the return and a reasonable return on investment, but there also needs to be the corresponding economical and efficient management consideration. Is that correct?
That is correct.
And that's one of the tasks that this commission must consider as well. Is that not?
That is true.
Okay. I want to go and refer to Mr. Cowling's testimony, and I believe his testimony is now being stipulated in. Is that correct?
Correct.
And so if you need to defer this to someone else, please do. But he made a couple of statements in his testimony that I'd like to follow up on. One was on page 17, where he stated, installing new LED fixtures to replace obsolete MV and incandescent technology results in a new product being connected to the existing electrical wires, thus a change in the character of service for the future. And I want to key in on that change in character of the service. If customers are having their obsolete fixtures replaced with LEDs, is this going to impact those customers that are on the Greenwood rate? Is that going to be considered a change in service for those customers such that they could be removed from the Greenwood rate?
I don't know the answer to that. I think that's a legal issue.
Okay. Can you task one of your witnesses to follow up with that, please, that we can get a response to that in this proceeding?
Certainly will.
Okay. Also, in Mr. Cowling's testimony on page 18, he stated, with respect to Greenwood outdoor lighting customers, there are other outdoor lighting service providers to choose from in addition to Duke Energy Carolinas. So a Greenwood customer will have available options. Would you happen to know those options, or is that something somebody else needs to? Outdoor lighting.
I don't know specifically what Greenwood customers, what options they would have, but I do know there are other companies that provide outdoor lighting, commercial companies
Okay.
that provide outdoor lighting services. Duke is not the sole provider. We provide the electricity, but in terms of the fixtures,
Okay. If a customer were to get one of those fixtures from another company, with Duke providing that service, what schedule would that be on? Is that a Greenwood rate, or is an outdoor lighting rate separate from the Greenwood rate?
I do not know the answer to that.
If somebody can let me know who can answer those, I'd appreciate it. So, thank you very much.
Thank you.
Thank you, Commissioner Belzer. Commissioners, any other questions? Smith, any redirect?
Yes, very, very little. Do you remember earlier this morning, Mr. Garchitego, when you were asked some questions by Mr. Colley on the Jeff Bailey testimony and exhibits?
I do.
And do we have other witnesses in the rate design department who would be able to address Mr. Bailey's testimony?
Yes. Mr. Pirro, Michael Pirro, is our rate design witness in this case.
Okay, thank you. And do you remember Mr. Colley asking you some questions about the company's decision to depart from its cost allocation methodology proposed in the 2013 rate case in South Carolina? I think he characterized it as a change from the last case. Is that correct?
Yes, I recall that.
Okay. And is it a change from North Carolina?
No. In fact, the minimum system cost of service study that we proposed in this case was recently approved in North Carolina.
And are there parties in this case who support the minimum system allocation?
Yes. I believe the ORS did not oppose it.
Okay. Do you recall Mr. Neal asking you about the national average of basic facility charges for investor-owned utilities?
I do.
And if you're looking at a national view, is it also important to look at a South Carolina view for utilities?
Absolutely.
And so how would that same statement work out if you're focusing on South Carolina utilities?
I believe I mentioned that there's a number of cooperatives in the state who have higher basic facilities charges than we do now, and then what we've agreed to in this case. And I think it's relevant because I remember he said something about whether we wanted to be a cooperative, and we do not. But it's relevant because there are neighborhoods where you have cooperative customers on one side of the street. I think in Lawrence County, I've met some customers from there, and utility customers close by. So they do talk, and they do compare rates.
Okay. And in the situation of co-ops, they're members, they're member-owned, correct?
Correct.
And so the members participate in those decisions about what the basic facilities charge might be?
Correct.
Okay. And do you remember, this is for Kim Smith, so Ms. Smith, one's coming at you. Do you remember when Mr. Elliott was asking you about the South Carolina piece of the Lee nuclear cost? Do you recall that?
Yes, I do.
And he wanted to know the system-wide number for Lee nuclear. Do you recall that?
Yes.
Okay, and is that North and South Carolina?
Yes.
Okay. And so did North Carolina allow recovery of AFUDC?
Yes, they did.
Okay. And moving on, Mr. Garchitego, do you recall when counsel for Walmart was asking you questions regarding the company's proposed return on equity?
I do.
And just one little thing to clean up for the record. Do you recall when counsel asked you about why the company chose to propose a 30% increase in its ROE? Do you remember the use of the word percent?
I do not remember that.
Okay. Well, just for clarity of the record, what is the company's current ROE, allowed ROE?
Allowed is 10.2%.
Okay, and the company proposed?
Is 10.5%.
And so would the difference then be 30 basis points, not 30%?
30 basis points.
30% would be a very different number, correct?
Absolutely.
Okay. Do you also recall when Commissioner Howard was asking you about low-income options for Duke Energy Carolina's customers? Do you remember that?
I do.
And do you recall conversations, for example, about prepaid advantage?
I do.
Are there other programs such as pick your own due date? Are there other options like that that can help customers?
Yes, pick your own due date. I think we heard some customers of the night hearings about inability to pick due dates, but that's one of the programs that's facilitated by the AMI meter. Customers can now absolutely pick their due dates to match up with when they get paid or when they have the money available, or for whatever reason. But that helps customers as well, particularly those in fixed incomes who have their pay or their checks coming in at particular times of the month, so they can better align their payments with when they get monies in.
Okay. And so the program you just referenced, Pick Your Own Due Date, and the Prepaid Advantage program that was discussed, both of those are relatively recent programs. Is that correct?
They are, and they're all facilitated by the AMI meter.
Okay, thank you. And before we leave AMI meters, do you remember Commissioner Belzer's question about meter testing?
Yes.
And do we have a witness in this case who would be able to talk about meter testing and these smart meters?
Yes, Don Schneider.
Okay. And do you remember Commissioner Belzer asking you about whether or not there were any savings that could be attributed to the company's proposal regarding credit card fees?
Yes.
And do we also have a witness in this case who would be maybe perhaps better suited to answer those questions of the Commissioner?
Yes, I think I said it was Ms. Quick.
There you go. Okay, thank you. And do you recall Commissioner Whitfield asking you some questions about cost allocation for generation?
Yes.
And so in a cost of service study, such as in a rate case, is it your understanding that you allocate away wholesale?
Yes.
Okay, which leaves the retail component?
Yes.
And what's the retail split between North and South Carolina?
For DEC, it's about 70-30.
Okay. Are you aware of any generation or transmission that is not split along those lines and shared costs between the two states?
I'm not
Or
aware
generating plants, for example, and transmission lines?
Yeah, I'm not aware of any generating plants owned by the utility, other than perhaps that which was constructed to comply with North Carolina REPS, or Renewable Energy Portfolio Standard requirements. But even there, we do assign based on avoided costs to South Carolina.
Okay.
It's North Carolina.
And Ms. Smith, when you calculate the revenue requirements for rate cases such as this one, how are the costs of the company's generating plants like Lee CC and our other generating plants and transmission lines, how are they allocated when you propose a revenue requirement?
They're allocated across the states,
Okay, and that split is?
70-30.
Okay, thank you. And do you recall, I'm almost done here, so thank you. Do you recall being asked about some of the smart meter issues that were raised at the public hearings? Mr. Garchitego.
Yes, I did.
Okay. And did you have with your team smart meter professionals that talked to some of those customers?
Yes, we did on each night of the public hearing.
Okay. And could perhaps Mr. Schneider follow up on some of those questions?
Absolutely.
Okay. Thank you. That's all I have. Thank you.
Thank you, ma'am. You're real quick. Rivals another attorney's real quick that I've had before here. I know that in my total immersion training back in November, when we have redirect, we can have some recross to those particular questions. So is there any recross? Step right up. 3 or 4, you said. Okay.
Yes, sir. A follow-up to the question that Ms. Smith just asked you regarding the difference between operating plants in South Carolina and North Carolina transmission lines. Isn't it true that last time Duke came in for a rate case that there were certain costs associated with the North Carolina Clean Smokestack Act, and I might be naming that wrong, that Duke voluntarily agreed not to include in costs associated to, or sent to South Carolina?
I do know there were some clean smokestacks charges that were not charged to South Carolina, yes.
Thank you. Another thing, there was
To be clear, once the Federal Clean Air Act was passed and changed, that cost, some of those costs are being shared between the two states now.
I think everything else is just related to commissioner questions, so I don't think those are proper. I think I'm done. Thank you.
Sorry to go out of order. Just quickly, Mr. Gardy-Tago, in relation to this question about comparing Duke Energy Carolinas to cooperatives in South Carolina, are you familiar with the Help My House program that cooperatives offer their members in South Carolina?
I am not.
Okay. So if you were to, subject to check, learn about this tariffed on-bill financing program, this inclusive financing program that allows for comprehensive whole house energy efficiency retrofits without any upfront payments by customers, would that be something you'd be open to exploring to offer to your customers in South Carolina?
Yeah, I'm willing to explore that if it will help my customers.
Thank you.
Thank you. Okay. Any other recross? Okay. Then, thank you for your testimony, and you may step down.
At this time, Mr. Chairman, we'd like to ask that Mr. Garty-Tago be excused. I would like to hold Ms. Smith on rebuttal to maybe come back and pick up some of the questions we might have some follow-up on.
Granted.
Just another housekeeping matter while we're transitioning here. We next will call Mr. Chris Fallon and Dr. Diaz to the stand. And while we're shifting around here, wanted to take care of a couple procedural matters. The company and parties had agreed to stipulate a few witnesses for Duke, and we'd like to enter their testimony into the record as if given orally from the stand. So this would include the pre-filed testimony and exhibits of James Cowling, Kimberly D. McGee, John Paniza, and that's direct testimony for all three of those witnesses. We would also like to move into the record, as if given orally from the stand, the direct testimony of Mr. J. Oliver, as well as Mr. Oliver's direct Exhibit 1. I would note for clarity of the record that while Mr. Oliver filed rebuttal and additional exhibits, they were related to the grid improvement plan, which has been withdrawn from this case, so we're not asking that those be entered into the record in anticipation that they'll form part of the new record in the upcoming docket.
Okay.
We have also,
before we get any further, I'm keeping up with you writing down, but I'm going to go ahead and do some of these, and then we'll
thank you.
We will enter the pre-filed direct testimony of Mr. Cowling, McGee, and Paniza into the record as if though given orally from the stand. Were there exhibits with any of those?
There were some pre-filed exhibits. We would ask that they be moved in as well.
Okay, for Cowling, how many?
I'm sorry, I don't have that. It was on our motion. I apologize. All right, I can make this a little quicker. Sorry about that. Thanks to some help I received here. So for James Cowling, he has 5 exhibits to his direct testimony.
Okay, Mr. Cowling's 5 exhibits will be hearing exhibit number 14, composite exhibit.
For Kimberly McGee, she had 1 exhibit on direct.
Okay, Ms. McGee's exhibit will be number 15.
Okay. And Mr. Oliver's direct testimony contained 1 exhibit, his direct Exhibit 1 that we're entering into the record.
Okay, we'll enter Mr. Oliver's as exhibit number 16.
Okay, and Mr. Panizza had no exhibits.
Okay, and we haven't entered, I don't think we've had Mr. Oliver, we didn't get to him his pre-file testimony would be entered into the record as if given orally from the stand. So we get that done as well. Okay, so far, go ahead, Mr. Dong.
Did we have verifications for all those witnesses?
We have filed verifications for all of those witnesses. The first three, their originals are being mailed into the commission, maybe in the mailbox right now, and we have brought an original of Mr. Oliver's, which we will provide to the court reporter on break.
Thank you very much.
With that, I will turn it over to Mr. Marzo.
Good afternoon, Commissioners. With your permission, Mr. Chairman, I will begin with Mr. Fallon and move to Dr. Diaz on direct. Mr. Fallon, would you
hang on 1 second? Let's get them sworn in.
Oh, I'm sorry. I do. Mr. Fallon, please state your full name and your business address for the record.
Christopher M. Fallon, 550 South Caldwell Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Renewables, and I am Vice President, Duke Energy Renewables and Commercial Portfolio.
Mr. Fallon, on November 8th, 2018, did you cause to be pre-filed in this docket 35 pages of direct testimony and one exhibit, Exhibit Fallon 1, consisting of 35 pages?
Yes.
Did you also pre-file an errata into your direct testimony on January 22nd, 2019?
Yes.
Do you have any other changes or corrections that you need to make to your testimony or exhibits in this case?
No, I do not.
Are they true and correct to the best of your knowledge?
Yes, they are.
Would your answers be the same if you were asked those questions today?
Yes, they would.
Mr. Chairman, at this time, I would ask that the pre-filed direct testimony of Mr. Fallon be copied into the record if given orally today.
The pre-filed direct testimony of Christopher Fallon will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. I'd also ask that Mr. Fallon's exhibits be marked for identification.
Okay. Mr. Fallon's exhibits will be marked as exhibit number 17.
Dr. Diaz, could you please state your full name and your business address for the record?
Niels Diaz, 3414 West Gables Court, Tampa, Florida.
And Dr. Diaz, by whom are you employed and in what capacity?
I'm employed by the ND2 Group, and I am the managing director.
Dr. Diaz, did you cause to pre-file in this docket 42 pages of direct testimony and 3 exhibits, consisting of Exhibit NJD1, consisting of 2 pages, NJD2, consisting of 1 page, and NJD3, consisting of 2 pages?
Yes.
Okay. Do you have any corrections or changes you need to make to your direct testimony or your exhibits?
No.
Are they true and correct to the best of your knowledge?
They are.
Would your answers be the same if you were asked those same questions today?
Yes.
Chairman, this time I would ask that the pre-filed direct testimony of Dr. Diaz be copied into record as if given orally here today.
The pre-filed direct testimony of Dr. Niels Diaz will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. I'd also ask that Dr. Diaz's exhibits be marked for identification.
Dr. Diaz's exhibits will be marked as exhibit number 18.
Thank you, Mr. Chairman. Mr. Fallon, do you have a summary of your testimony?
Yes, I do.
Ms. Fallon, would you please give that summary?
Good afternoon, Commissioners. I filed direct testimony in this case. My direct testimony provides background on the Lee Nuclear Project development activities and associated costs. In our application in this case, Duke Energy Carolinas requests recovery of the South Carolina allocable share of project development costs of approximately $125 million. As I will explain, these costs were prudently incurred for the benefit of Duke Energy Carolinas customers. Duke Energy Carolinas customers and the communities we serve have benefited greatly from Duke Energy Carolinas' nuclear fleet and have enjoyed safe, reliable, emission-free, and cost-effective energy for decades. In the 2005 timeframe, Duke Energy Carolinas' Integrated Resource Plan identified the need for significant generation capacity additions. The generation planning environment at this time was characterized by extreme volatility in natural gas prices, the expected impacts of the 2005 Clean Air Interstate Rule, and other possible carbon-limiting environmental regulations, as well as the positive support for nuclear generation afforded by the Energy Policy Act of 2005 and the actions of the South Carolina General Assembly. Based on these considerations and other factors, Duke Energy Carolina has identified nuclear generation as the least cost supply-side alternative. Consequently, Duke Energy Carolina has started development work on new nuclear as an option to meet its customers' needs and announced in 2006 the selection of the Lee site for possible nuclear expansion. Duke Energy Carolina has filed a combined license application in 2007 with the Nuclear Regulatory Commission. Also in 2007, the company filed an application for approval of decision to incur nuclear generation pre-construction costs with this commission to ensure the project remained an option to serve customers when needed as identified in the company's IRP. On June 9, 2008, the commission issued an order approving Duke Energy Carolina's decision to incur pre-construction costs. In 2011, Duke Energy Carolina has filed an additional project development application requesting approval for additional pre-construction costs. In July 2011, the Commission approved a settlement agreement among Duke Energy Carolina's ORS and some of the intervening parties. In accordance with the Commission's order, the company continued to incur only those costs necessary to keep the Lee Nuclear Project available as an option in the time frame as it was needed to serve customers, and the company kept the Commission abreast of that progress through regular reporting. At the time of the Commission's 2011 order, Duke Energy Carolina projected that it would receive the COL in 2013. However, the receipt of the COL was delayed by several factors, many of which were outside Duke Energy Carolina's control, as Dr. Diaz explains in his testimony. Duke Energy Carolina has continued to incur costs for Lee Nuclear Project in order to preserve the option of building Lee Nuclear Project to have it available to meet the need dates contained in Duke Energy Carolina's IRP. Capital spending on the Lee Nuclear Project after 2013 declined substantially as project development activities continue to be significantly limited to only the minimal amount necessary to keep the nuclear option available. Throughout this project, Duke Energy Carolina has taken a methodical, deliberate, and measured approach to evaluate and pursue new nuclear, which has allowed the company to maintain nuclear as a future option while also avoiding some of the significant challenges that have been encountered by early adopting utilities who have undertaken full construction. Duke Energy Carolina has been consistent that it would make a decision regarding construction of the Lee Nuclear Project after receipt of the COL. The COL for the Lee Nuclear Project was received at the end of 2016. Since that time, significant events outside the control of Duke Energy Carolina, such as the bankruptcy of Westinghouse, the exit of Westinghouse from the construction business, and the abandonment of the VC Summer project, have led Duke Energy Carolina to the conclusion that the project, as originally envisioned, is no longer prudent to pursue. As a result of these risks and uncertainties, abandonment of the Lee Nuclear Project is now the best option for our customers. The company will continue to maintain the COL. The COL does not expire and has value for Duke Energy Carolina's customers because it eliminates the long lead time required for federal permitting and authorization of nuclear construction, and will allow Duke Energy Carolina to pursue the option of future nuclear at the Lee site when and if it is when it is best for our customers. This concludes my summary.
Thank you, Mr. Fallon. Dr. Diaz, would you please give you a summary of your testimony?
Mr. Chairman, Commissioners, it is my distinct privilege to testify before the South Carolina Public Service Commission. The purpose of my direct testimony is to review the reasonableness and prudence of the strategy and efforts of Duke Energy Carolinas, here called the company or the Carolinas, to secure a combined construction and operating license, or COL, for the Lee Nuclear Project. I conducted an overall review of the decision-making process throughout the project and examined documentation related to significant lease COL application issues and events, using management strategies, schedules, and COL review matters as performance indicators. I determined that DE Carolina's decisions and actions to take a stepwise approach to licensing and managing the Lee Nuclear Project and its decision to extend the unit's target operation dates were reasonable and consistent with industry best practices. The company identified the need to begin planning for nuclear through its Integrated Resource Planning IRP process in its 2005-2006 annual plans. At the time, the nuclear industry was experiencing a strong renewal due to improved regulatory stability, improved technology, and improved economic factors. Accordingly, DE Carolinas decided to pursue new nuclear in this favorable environment to ensure the availability of cost-competitive, reliable, and predictable electricity generation for its customers. DE Carolina submitted a COL application to the Nuclear Regulatory Commission, NRC, for 2 AP 1000 reactors on December 13, 2007. The NRC docketed the company's COL application in February 2008. Concurrently, DE Carolinas established a project management organization for the Lee Nuclear Project to actively pursue the COL and to conduct those activities necessary to maintain the viability of the project. To ensure full disclosures of the plans and activities and to address cost recovery needs, DE Carolinas applied for approval from the Commission relating to costs incurred to develop the Lee Nuclear Project. After an extensive review of DE Carolinas licensing plan for the Lee Nuclear Project, the Commission issued 2 separate orders approving project development cost recovery. Importantly, the company employed a licensing-first strategy and began the licensing process early enough to accommodate potential delays in order to exercise the license when it is most beneficial to DE Carolina's customers. The company continued to make cost-conscious decisions, including deferring long lead procurement decisions and costly site work. The company did not enter into an engineering, procurement, and construction contract. In fact, the company followed the 3 baseline actions recommended by the 1992 Energy Policy Act. First, licensing decisions are to be finalized before major construction begins. Second, utilities will order plans after regulatory and financial risks are mitigated by satisfactory completion of the new licensing process. And third, the use of standardized, safer reactor designs are encouraged. My testimony also explains that DE Carolinas faced numerous issues during the licensing process that impacted the timing for the issuance of the Lee COL. The major issues that impacted the Lee COL review include delays related to the Yucca Mountain Review, Waste Confidence Rule, Fukushima Daiichi accident, seismic source characterization for the central and eastern United States, and the implementation of the new 10 CFR Part 52 licensing. My testimony provides detailed facts and circumstances surrounding each of these delays. The issues in their aggregate resulted in the licensing process taking significantly longer than originally anticipated for the Lee Nuclear Project, as well as other projects. It would be demanding to license a power reactor under normal circumstances, but the period between 2008 and 2016 was especially demanding. The NRC ultimately issued the Lee COL on December 19, 2016. Finally, my testimony discusses the near-term impacts of the Westinghouse bankruptcy and overall reorganization. I explained that with Westinghouse exiting the construction business, it will be important for DE Carolinas to evaluate project execution strategies for new nuclear and establishing how engineering, procurement, and construction will be undertaken to adhere to a reliable cost and schedule. Ultimately, I concluded that the Carolinas' decisions and actions to take a stepwise approach to licensing and managing the Lee Nuclear Project and its decision to extend the project target operations days as established by the IRPs were reasonable and prudent and consistent with industry best practices. The COL has intrinsic value by providing the capability of deploying a nuclear power plant when it is most beneficial and I'm sorry, there's something wrong in here. When it's most beneficial and can operate the plant for a license life of 40 years with the possibility of additional license extensions. Customers should benefit from the Lee COL and project development for a long time after its deployment. This concludes my testimony.
Mr. Chairman, the witnesses are available for cross-examination.
Thank you. Before we get to cross, I just want you to know I did see all the looks of apprehension from all of you when Mr. Dong left the bench and left me driving by myself. But we'll begin cross after a short break.